Welcome everyone to yet another Belgrade Legal Theory Group event. Before we begin, I would just like to point out that today we are witnessing a sad fact that one of the greatest or the most famous legal philosophers of our time, Joseph Raz, has passed away. So just a brief notion and information for those of the people that haven't heard the news already. But moving on to the current events, we are pleased to welcome once again our dear friend and colleague, Victor Garcia from Chile. Today he will be presenting his paper on a very interesting topic concerning precisely the field of legal philosophy, concretely legal interpretation and the creation of law by the judges. It's named Antecedent of Norms and Implicit Exceptions, an Analysis Proposal. So you all know the procedure. Victor, you have 20 to 30 minutes for your presentation, after which comes the Q&A part. So without further ado, you have the floor. Thank you.
Thank you very much, Saba. Good afternoon. I want to start by thanking the Belgrade Legal Theory Group for the opportunity to make this presentation, especially to Anna for managing it. It is a genuine pleasure to be able to see some good old friends again, to make new ones, but mainly to get this chance to discuss these ideas with all of you. I put myself, I want to say also, I'm sorry if my pronunciation of the English is not very accurate. It's not my mother tongue, I think, for none of us, and also maybe a little bit nervous, but nothing more. Well, the purpose of this presentation is to present and clarify a set of discourses that juries, mainly legal scholars to be more accurate, usually make to describe part of the judicial practice. Specifically, juries often point out that judges, in order to avoid solving a problem incorrectly, unfairly, or even inefficiently, create an implicit exception in order to change the normative qualification of a certain action. Faced with this type of statements, I believe that two questions can be asked and that I will try to answer in the following minutes. The first question is, what are we talking about when we talk about implicit exceptions? And the second one is, does a certain property qualified as an implicit exception means attributing to it a particular characteristic in the sense of it is a type of fragment of the antecedent or is it a type of norm? What are we talking about here? In order to answer the first question, I'm going to make a brief analysis on how legal theories have proposed to understand the notion of implicit exception. In this regard, I'm going to review the specialized literature on implicit exception that can be, I think, distinguished in two main ideas. The first one is that for some legal scholars, when we talk about implicit exceptions, we are talking about an implicit assumption of a norm that has been explicited. And for the second idea, another group of legal theorists, what they are saying is that when we are talking about implicit exceptions, we are talking about the substitution of a norm for another one that contains, in comparison, a new relevant property in the antecedent, that is, contains more distinctions in the antecedent. In relation to the second question, from the different ways of understanding the notion of implicit exceptions, it can be concluded, I think I'm going to sustain this, that we are not talking about a structural element of the antecedent, but rather we are presenting an operation and its result. In more precise terms, when we talk about implicit exceptions, we are not using the language of norms. Instead, we are using a proposition or a description of a norm based or designed by emotional or strategical purposes. Well, I will get to this point. Before I start, I must clarify that in this presentation, I will assume first a non-cognitivist conception of interpretation, and second, that I will understand that norms relate to each other in a closed deductive system. Basically, I will adopt Carlos Alchurron and Eugenio Bulligin's notion of normative system for my analysis. Well, I will start by taking care of the first question. For clarity, I think it's appropriate to start with an example. During COVID-19 pandemic, a large number of countries have implemented a series of measures that restrict freedom of movement in order to reduce the rate of infection. In this context, let us imagine a country that implemented a mandatory quarantine regime that prohibited people from leaving their habitual residence, but not a very strange case, right? So those who violated the quarantine were sanctioned with a fine, and the immediate consequence of this, of course, are a series of personal effects of different kinds. These personal effects of different kinds were particularly harsh on a certain group of people that lives with autism spectrum disorder, with ASD, or at least for a certain group of these people. For them, this was a disturbance of their daily routine that produced a noticeable increase of severe anxiety attacks. In this context, let us imagine a father with a minor with ASD that decided to take his son out of the house and make a short walk down the street so that he will feel better this day and wouldn't have an anxiety attack. Once in the park, a policeman stops them, imposes the fine, and in addition orders and coerces them to return home. Let us imagine that the fine is appealed, taken into court, and the judge considered that, despite having verified the antecedent of the norm, its normative consequence should not be imposed, since the departure from home was due to health needs, and these health needs operate as an implicit exception. So, what are we saying when we describe the judicial practice like this? What are we talking about? Well, for a group of legal theories, when we talk about implicit exception, we are talking about an implicit assumption containing the antecedent that has been made explicit. So, what jurists say, what jurists are doing when they speak of implicit exception are giving speeches on how norms should be identified. The main thesis is that when we identify a norm, we tend to make incomplete presentations of the antecedent, since we assume certain properties that we leave unexpressed. When these presupposed properties are made explicit, they operate as scope constraints, that is, as an implicit exception. This means that the relevant points when we discuss about implicit exceptions are how we identify these implicit assumptions and what does it mean to make them explicit. These are the two main points, I think, about this topic. In this regard, in specialized literature, we can identify three ways of understanding what an implicit assumption is and what does it mean to make it explicit. Briefly, a first way of understanding the explanation of an implicit assumption is as a result of a review of our beliefs about the relations between norms in a normative system. Let me be more clear. Let us suppose we have to solve a normative problem. This is, we need to find out what is the normative qualification of a certain action. In a first moment, our analysis of the content of the antecedent of a norm qualifies an action in a certain way. However, if we take into consideration the rest of the norms that are part of the normative system, we realize that properly understood the whole normative system, then action is qualified in another way, is normative qualified in another way. The classic example is presented, has been formulated initially by Carlos Alchurron. So let us imagine, actually the articles 106 and 20.2 of the Peruvian Criminal Codes says the following. From the first article, 106, we can identify a norm that prescribes the obligation to punish those who commit homicide. While the second article, 20.2, we can identify a norm that says that it's prohibited to sanction minors. If we have a case of a certain minor, for example, John, a minor of 16 years old that kills Patrick, according to Article 106, we can infer that John should be punished for the homicide. And by Article 20.2, we can infer that he should not be punished because he is a minor. Now, we are now in the moment of asking ourselves what is the correct interpretation of both of these statements. One option is to understand that being a minor operates as an exception to the norm of sanctioning homicides. So we should reformulate the norm as if a person commits homicide and is not a minor, then it's mandatory to punish him. Of course, we can make the interpretation in the opposite way, that the norm of homicide is an implicit exception for the norms of the minor. He decides how norms relate to each other. But this points out, or this makes me, or this allows us to highlight certain idea, that the creation of an implicit exception is the product of a systematic interpretation. Systematic interpretation understood as an interpretative directive that we must identify norms in such a way that they do not conflict with other norms previously identified. In this way, the implicit assumptions are all those prescriptions, other norms contained in the normative system, and when we say make them explicit, it's just a way of presenting the need of creating a preference relation between them to decide how they relate to each other, which one has more weight, to say it in a way. So this is the first option, or the first way of understanding implicit assumption. It's not the only one, and of course not the main one. A second way of understanding the explicitation of implicit assumption is through the incorporation of a new property in the antecedent of the norm as a result of a better specification of the justification of the norm. Well, for some legal scholars, norms are understood as means to achieve purposes. So, the interpretative work must be aimed at correctly identifying the prescriptions, that is, that they are in accordance with their purpose in every moment or every instance of application. In this view, they assume that the scope can and should be varied in order to reduce it, if in this way we better specify the purpose of the norm. In this sense, purposes are the source of the implicit exceptions to the prescription. An example of understanding this kind of approach to implicit exception, has been made by Eugenio Bulin and also by Frederick Schauer, but we can talk about Schauer if you want in the Q&A part. For Bulin, when we are reading a provision, when we are reading a statement without taking into account its purpose, we are not understanding correctly the meaning of the expressions used by the legislator. Classic example of this point is the law of Bologna that said, whoever spills blood in the streets should be punished with severity. We can imagine cases where a barber accidentally cuts his client and therefore spills his blood in the street, a doctor who performs an emergency intervention in the street and implies that the patient bleeds, or the case of a child that playing with another one breaks his nose and makes his blood splatter in the pavement. Under literal interpretation, all these cases should be punished severely. Now, under an interpretation according to the purposes, that is, looking for the reasons why it was formulated, this would exclude all cases that doesn't satisfy the purpose. Let us assume that this rule was issued in order to discourage fights, duels, or other violent acts on public roads. Of course, the case of the barber, the doctor, the children are not ways of satisfying these purposes. In this sense, there is an implicit assumption in the norm, this is the purpose, and when we say make it explicit, this is just a way of presenting the use of the argument of legal purpose in order to reduce the scope. So, in structural terms, maybe this can be understood as including an unless clause that says, and if not, and it is not the case of playing or performing a professional act or so other similar activity. Of course, this will be an open or indeterminate clause. In this way, implicit assumptions, I insist, are just a way of saying of presenting the purpose, and make it explicit is just a way of using the theological argument to identify the content of a norm. And third, finally, a way of understanding what is an implicit assumption is by replicating this exercise, but substituting the idea of purpose of the norm for the idea of intention of the legislator of the norm. Briefly stated, an implicit assumption is a way of presenting that an interpreter is arguing, is defending a distinction in the antecedent that the legislator would have made if he had the opportunity to do so. In this sense, we carry out a contrafactual judgment of the will of the legislator who identified the types of actions or situations that he would exclude from the scope of the application of the norm if he had the time to do so. This approach or this idea has been presented very well, very clearly by Carlos Alchurron with the proposal of a dispositional approach to the feasibility. So according to this approach to the feasibility, we should ask ourselves, what will be the evaluative attitude of the legislator regarding a certain circumstance? If we conclude that he would have regulated in a different way, then we should not qualify normatively this action with a certain normative consequence, but we should make a distinction. So implicit assumption are the contrafactual judgment, and making explicit is just to incorporate a new distinction in the antecedent. As we have seen, these three theoretical proposals start from different theoretical presuppositions, but they all share the same idea, that implicit assumption is a property that is incorporated in the antecedent after a process of making explicit one or some implicit assumption. All these theories are assuming a way of understanding that the antecedent of a norm is not completed. This in the sense that the interpreter must carry out a subsequent interpretative acts in order to identify satisfactorily which is the norm that is part of the normative system. This implies that when interpreters identify implicit exceptions, they are not changing the norm, they are not incorporating a new norm, they rather are identifying it in a correct way. A norm with an incomplete antecedent expresses a norm with an antecedent that contains only contributing conditions for the consequent. When we identify the correct or with the satisfactory norm, we are saying that the antecedent is complete in the sense that we have done our the homework to identify the sufficient condition for the consequent, or if the case, a necessary and sufficient condition for the consequent. Implicit exceptions under this way of understanding them accounts for the properties that are incorporated using express regulations, using purposes of the regulations, intention of the legislator, all of this to be able to consider that we have ceased to have contributing conditions, and now we can say that they have at least a sufficient condition for the consequent. This point is theoretically relevant since it allows us to state that implicit exemption is not a way of accounting for a structural component of the antecedent, but rather they are presenting an operation. But I will return to this point in a few minutes. Well, this is the first path. Let's see the second path of how we understand, or how, legal scholars have understood implicit exception. For another group of legal theorists, when jurists speak of implicit exception, we are doing something different from what we just talked about. they are talking about the case of the substitution of a norm by another one. The main thesis is that judges can create new norms so that the regulation of an action or a state of affairs conforms or is accordance to a standard of justice, or in more precise terms, to satisfy a criteria of correctness that they themselves have established, that they themselves have decided. In this regard, only for reasons of time, I am only going to present briefly one of the most clear ways of presenting this idea made by Andrea Dolcetti and Giovanni Battista Ratti. For these authors, these kind of discourses are better understood as a case of a conflict between an explicit norm and an implicit norm, in which the judge prefers the result of the implicit norm. Let me be more clear about this point. When we talk about explicit norms, we are talking about norms that has been identified as the product of having attributed meaning to a statement. This is the exercise, for example, that I have done minutes ago with the Article 106 of Peruvian Criminal Code. An implicit norm, on the other hand, accounts for norms that has been created by judges. Therefore, there is no text that has been subject of interpretation. They are creation of the judges in a decision. The scenario we are interested in analyzing is a case of an explicit norm that conflicts with an implicit norm. Under these circumstances, if the explicit norm wins, this is not very interesting for us. It's just a case where the explicit norm has been evaluated, we have considered reasons against it, and we have concluded that none of them are sufficient to change the normative qualification of the case. Different is the situation when the judge decides that the implicit norm is better, has more weight. In this case, we have a conflict between two norms, and the judge decides to left out, to not use, to consider that he doesn't have the duty to use the explicit norm, but rather he has the duty to use the implicit norm. He has two creation acts. First, he has created the implicit norm, and second, he has created the preference relationship between these two in order to prefer the implicit norm. This is the case, for example, of the initial situation of the quarantine case. We have an explicit norm that could be identified from the sanitary regulations, and an implicit norm that has been created for the case, that people that suffer from anxiety attacks due to live with ASD should not be regulated by these quarantines, and he prefers this second one. But well, after doing this literature review, let me get back to the initial two questions, the purpose of this presentation. For the first one, what are we talking about when we talk about implicit exceptions? In the first place, the different theorizations about implicit exceptions do not deal with clarifying structural components of the antecedent. What these try to clarify is a set of operations carried out with norms and their results. Legal scholars, when they talk about implicit exceptions, they are clarifying interpretative processes that judges carry out in order to satisfactorily identify a norm. Of course, in brief summary, these processes can be of two types. According to the first type, it's a process of better understanding what the prescription is, or what the prescription is contained in the normative system. An implicit exception from this group of theories is just an explicitation of an implicit assumption. And this implies two things. First, when we explicit an implicit assumption, we're not changing the norm. What we are doing is identifying it correctly. And second, that the best way of understanding the antecedent of a norm, at least at the first moment, is using contributing conditions for the consequent. Later, in a second moment, all things considered, we will use sufficient conditions. This point, I think, what allows us to see is that they are dealing with mainly an epistemic problem. What what needs to be done to identify correctly, according to your justice feelings, what is need to do, what we need to do to get some sufficient conditions for the norm. The second type of process is a process of law. It's understood as a law creation process made by the judges. An implicit assumption within this type of theories is understood as the replacement of a norm by another one that contains more distinction in the antecedent. What they are saying is that implicit assumptions are just a way of expressing, first, a creation of law by judges, and the second one, that the best way to identify an antecedent is always using sufficient conditions for the consequent in all moments. And this, I think, it highlights or presents us a different problem, an evaluative and normative problem. That is, which distinctions should be made, should be created in order to make the judgment a correct judgment. For the second question, is an implicit exception a type of fragment in the antecedent? Is it a type of norm? I think neither, none of these. If what has been stated these minutes is correct or at least makes sound, then it makes no sense to predicate in the antecedent of a norm that certain fragment is an exception. It's not a type of condition, not a type of property. When we talk about creating an implicit assumption, this only allows us to present how to pass from contributing conditions to a sufficient one from the first type of theory, and from the second type of theory, how we pass from one condition, sufficient condition, to another sufficient condition. We are dealing with the same variables. This shows us, maybe, I think, that the best way to understand what an implicit exception is not from the theory of the structure of the norms, nor by analyzing the type of norms, rather on the level of normative propositions. Said more clearly or more precisely, it is a part, it's a way of elaborating a meta-jurisprudential discourse that allow us to better present a type of operation and a type of result that we just reviewed. In fact, I think that what we have seen, what we have just discussed, show us that the usual distinction that jurists make between requirements for application of a norm and exception is a false distinction. This for two reasons. In a structural level, both requirements and exceptions operate in the same way. They are either contributing or sufficient conditions for the consequent. We are dealing with the same pieces of the puzzle. And also, both of them relate to other condition, other properties contained in the antecedent in the same way, in an inclusive disjunction. Also, when we are trying to explain how to create an exception, this is the explanation on how to identify a norm that we consider correct, nothing more. What is different from exceptions and requirements is the emotional charge associated with exceptions, or at least with the word exception. To present a fragment of a norm as an exception, an implicit exception, is usually made in order to say that a change has been made, or to justify to treat some group differently. In this order, for example, or this is in order, for example, to use some ideologies of interpretation, such as that exceptions should be interpreted in a restrictive way, for example, or as a discourse in order to avoid judges to create new norm, as a conservative discourse against judicial creation of law, for instance. Whatever the case, the analysis presented, I think, allow us to say that is to describe a fragment of a norm as an exception is just an option from many others to explain what just happened, to explain what the result of a systematic interpretation, to explain the result of a teleological argument from the intention of the legislator or a judicial creation of the law. Also, from what has been said, I think from a theoretical point of view, this distinction allows us to divide two ways of understanding legal system and legal interpretation. The first group of theorizations, this is implicit exception as an implicit assumption contained in the antecedent, is trying to clarify what the jurists are saying when they point out that the identification of a new property does not imply a change in the norm or a change of the normative system, but a better identification of the normative system. This sounds, I think, very close to the speeches of some principalist authors that usually make. And on the other hand, the second group of theorizations, implicit exception as the substitution of an or for another one, is trying to clarify discourses of jurists who consider any modification of the antecedent an act of creation of law by judges. In this sense, I don't think that one theorization is better than the other one. Each one highlights different information that allow us to make better reconstruction of the discourses of the jurist. Well, I thank you very much for your time, for your patience, and of course I'm at your disposition for any questions or discussion.
Thank you very much, Victor, for your great presentation. We now proceed with the usual part of the debate, the questions following. So I presume we can collect firstly all the questions and afterwards you can answer in some.
Okay.
So we have Bojan.
Thank you, Victor, for a wonderful presentation. It was perfect, and we haven't had a presentation on implicit norms, and for quite a while we haven't had a presentation that deals with the components of normative components of a legal system with antecedents and consequence. I don't know how much the others are used to this kind of analysis, but it was definitely most interesting to me. So this is, you made a fantastic job in presenting the positions. And I was thinking while you were talking about the different descriptions of what happens when an implicit norm is either created or their move was made in the antecedent to make it more precise in the interpretative way. So I have the first question regards the coherence of the presentation. In this sense, at the beginning, you said that you adopt a non-cognitivist approach to legal interpretation, but doesn't the first group of views, Alturon, I think, and Boligin, you mentioned them as exposing the first group of views, entail actually a cognitivist view on interpretation? So that is the first question. Could be a misstep in the presentation or something like that, but I wanted to clarify that. The second would be this interesting thing that I'm sure that you're aware, this interesting move of theories of legal interpretation from semantics to pragmatics. And now pragmatics is the dominant strain of linguistic analysis or communicative analysis when it comes to law, or at least many people are doing it with many interesting criticisms like the ones from Francesca Poggi or Paolo Sandro, who was our guest a couple of weeks or months ago. I don't even know when exactly, but the idea would be this. It's basically I think that I want to hear your comments on this. Could we reframe the issue of implicit exceptions as actually a question of the communicative content of the source of law or of the linguistic formulation of the legal norm in this sense, especially when it comes to the first group of theories? Would an alternative be that we are actually what we are doing when we are making the antecedent more precise? We're basically pragmatically enriching the antecedent or if we have a dilemma if to pragmatically enrich the antecedent in order, for example, to include or to exclude the father with a kid going out during curfew, could we plausibly interpret that as a pragmatic enrichment of the original formulation of the legal norm? Would that be a plausible, let's say, description of what happens when we're formulating, let's say, formulating an exception in this case? Look, when it comes to me, I think, I mean, Douglas-Tinian and explanation done by Ratti that we are formulating implicit norms and the norm is partially contradicting the norm that was explicitly formulated does it for me. But I just want to hear your thoughts on this idea that actually we don't have to frame it as this teleological or intentional thing, but we can frame it as a matter of communicative content of the wording of the source of law if we take into account the pragmatics of legal communication. Thank you.
Thank
you. I also have a few questions until perhaps someone else also wants to ask. First of all, I would like some sort of a clarification because I'm not certain if I've interpreted that part of the presentation well. You've mentioned the first three approaches which are different from, or the first approach which encompasses three different views or uses three different arguments, and you've mentioned the systemic approach, the teleological, and the third was the intention of the creator, if I recall correctly. And you stated that these approaches are different from the second one with regard to the question whether or not they actually create a new norm or not. And you said that they actually want to interpret that legal norm in a way saying that it's a better meaning, it's a better interpretation of an already existing norm rather than creation of a new norm. But what I'm interested in is the fact, and through the example that you've given, and if I recall, it's the shedding of blood on the streets from the medieval ages. It seems to me that that's a clear form of a teleological reduction, which is actually a creation of a new law, because it seems to me that it goes out of the linguistic borders of the term, and that's quite obvious that it does. So from that perspective, it seems to me it's also a form of a creation, not just an interpretation. So that's the first question regarding the clarification. Secondly, I don't think that you've mentioned that during the presentation, but you elaborate on that question in your paper. It concerns the second part of the arguments, the axiological gap, and the situation when the judge wants to fulfill that gap through creating a new law, actually. And what I'm interested in is on what is actually that sort of a creation of law based when it comes to the axiological gap, because you also mentioned some sort of an example regarding the Christian Adventists and the duty to work on Saturday. So I'm curious whether or not that necessarily leads us back to the constitutional principles and the existing values of a society, or is it perhaps purely deontological, meaning that it's based on the idea of fairness or justice or something similar to that. And finally, just a general question, but I think you've touched on it a bit during the presentation, since we're talking about a relative, in a way, relative creation of law or exemptions or exceptions from a general case from the judges, by the judges. What's your take on the idea, or in general, the relationship between legal certainty and this sort of an approach? Just a bit more, if you can give us on that topic.
Of course.
So that's it. Thank you.
Well, thank you very much for these questions. I mean, I hope to answer them in precise terms. For the first one, as a matter of coherence, of course, Alchurran and Boulin are cognitivist authors, but I think, they are treated usually as cognitivist authors. But I think I can do an answer in two parts. The first one, they assume a certain, I think, ideology of interpretation. They assume that the text should always be interpreted in a literal way, or using the semantic content of the words that are in the normative statement. But this can be, I think, distinguished from the operation they are trying to reconstruct, or they are trying to present, in the way of, I think we can still use the legal frame, the theoretical frame, of these authors in order to explain interpretative actions, even though we use a different kind of theory. In the case, for example, of bullying, a classic cognitivist, bullying, in a famous paper when he discussed with I think with Brass, well, a famous paper that he had, he argues that words used by the legislator can be distinguished, or we can distinguish two different senses. And I think this will connect with the second part, the literal one, the semantic meaning, and the purpose why this word was chosen, the context in which this certain phrase was written, the idea of why we are choosing this way of constructing a statement. And he argues that we can identify this purpose, or this reason why this elaboration has been made. And he thinks this is a discovery act, that we can actually find out which are these purposes. We can discuss, of course, if this is accurate to describe as a description of the purpose, or rather as an attribution, a decision made by the interpreter to understand this way this purpose. In other words, we can describe, of course, the purpose in several degrees of abstraction. Depending on which degree of abstraction, the meaning could change, or the way we understand this purpose can change. I mean, I can describe, for example, the Bologna law as a way of avoiding fights in the street, or as a way of saying that I am going to guarantee peace in the city. It's not the same, it's not the same. We are not saying the same, even though we are trying to describe the same thing. And I can choose this degree of abstraction, I think. Well, for the first part of this answer, I think that even though they are assuming a cognitivist approach of interpretation, we can use their ideas to explain legal processes, even with a non-cognitivist approach. And for the second part of this idea, at least for Carlos Alchurron, I'm not sure that it's fair to him to describe him as a cognitivist. In Law and Logic, which is a paper I tried to reconstruct for the use of contrafactuals in order to find out the legal intention, I think he is clearly a non-cognitivist there. You create the contrafactual judgments in order to make the distinction, or to create the implicit exception. Of course, we can discuss this a little bit more. In in order to the second question, if about the use of pragmatic level to understand legal interpretation. The first part, I must say that I must think about this a little bit more. I'm not familiarized completely with this type of literature. This is my fault, of course, but I can say this. We can understand enrichment as a way of understanding the context of a discourse. I mean, if I say, of course, here is, and I can say any statement. If we understand the context, the place, the moment, and the things that allow us to comprehend why I have said this, we can enrich the meaning. The pragmatic level enriches the semantic level. I have, in this sense, I think they are presenting something similar or even the same idea that I was trying to present with the first type of theories. My point is why we should use the label exception in order to describe this kind of operation, this type of operation, and why I think this is a relevant question. If we use the label exception in order to describe and differentiate the enrichment, the parts of the arrangement from the other parts, I think we are trying to say something, even in a pragmatic level. I'm trying to make the people that are hearing me, the normative subjects, to say it in a way, I'm trying to say them something. And I think this something is not accurate, or at least is not emotionally free. It's meant to be. I want them to treat someone, to treat some people differently. I want to show that this enrichment should get a different treatment from the rest. And this, I think, if we understand this as a structural part of the meaning or of the norm or as a structural part, we are saying that this is like this. I think not. I think that the correct level of the speech to put these ideas, to use this level, is as a description, that we are trying to make something with the norms by describing it like this. We are trying to highlight this as a different thing, to use, as I said in the presentation, to use some interpretative ideology to do something with it. You know, it's not I'm sorry, I'm trying not to say the same expressions again, but I will say it's not emotional free. In the opposite, it's charged with emotion. It's charged with certain ideas that we do this. If we can construct a logical distinction between requirements and exceptions, of course, my thesis will be wrong, and we can start by thinking ourselves the criteria of identification of exceptions and their implications. I think this is all an illusion, that we are actually, legal scholars are not trying to do this, and we actually, when we describe something an exception, we don't achieve this. And later you tell me if I answered you or not, or maybe now, whatever. And for Saba, well, first, in the case of Bologna, if this wouldn't be a case of law creation, of course, I mean, the Bologna law can be used as an example of different theories or different interpretative operations. When Buligin used this example, he thought it will be clear, it will be undiscussed, it is a clear case that this is the purpose, that he was trying to show an example of discovery of the purpose. If we assume a non-cognitivist approach, I mean, if we assume escepticism, there is no discovery. We have no true or false criteria in order to evaluate this type of statements. I think it's a normative statement that is what he's saying, that the text is better understood, or we should all understood the purpose of this text as the one that I avoid fighting in the streets, avoid chaos in the city, and all of this. In this way, I agree with the idea that the theological argument is a way of creating law. This is in a personal level. If I didn't do this in the presentation because it will be a misrepresentation of the author I was trying to reconstruct, but I agree completely that this is a way of creating new norms. About the axiological gaps, well, this is the source of this and the criteria to create and solve an axiological gaps. Of course, there are several, or to be more accurate, is a decision, I think, of the interpreter. I think, on one hand, they can use, of course, constitutional principles, moral principles, all the instruments you want. But I think they are all elaborations, they are all instruments in order to construct an interpretative ideology of the interpreter to create to make the real world more according to what he thinks that is the ideal world, that he's trying to use his competence of making judicial decisions, precedents, in order to change the world, in order to make it more accurate to what he thinks is fair. I mean, to be more, to be not so skeptical. For example, in the University of Alicante, Manuel Atienza and Juan Ruiz Manero usually says that we should create and solve axiological gaps, in order to make more objective moral judgments, in the sense that we should create axiological gaps and solve them the way that any reasonable person would agree with. Okay, which is the reasonable people? Of course, the one in the mirror, just to be clear. And for the last one, the relation between exceptions and legal certainty. Well, I think this is a difficult question. On one hand, I think we should make this question or we should be thinking of this question when we are analyzing and thinking about the competence of judges in two ways. We can create, or we can justify the creation of an exception if we value that the consequence of a norm are unjust, incorrect, inefficiently. But this means that I am a judge that in a degree understands the impact of my decisions. I mean, I can foresee with certain degree of probability that I'm going to create a disaster if I use this norm. But this is a bold statement. For example, here in Chile, we have no tax judge in the Supreme Court. They don't understand tax law. The tax judges are on the lower courts. So when the Supreme Court deals with the tax norm, with a problem about taxes, they really cannot foresee with certain degree of probability what are the impacts of their decision. They don't understand. They are not trained in this type of discussion. So are they more suitable? They have the institutional conditions, to say it in a way, for making these kinds of predictions. This from one hand, and from the other hand, if I am a judge of a lower court and I can create exceptions, then we have no rules. We have no way of making predictions. We have no legal certainty. But if my decisions we have started the thesis about my decisions. I must follow myself, and other judges must follow my decisions. Then we have a certain degree of legal certainty. So, in order to analyze the relationship between exceptions and legal certainty, I think this is a work to be done. We have, for one hand, the cognitive is if they have the competence to make accurate predictions of their consequence, if they can understand the impact of their decisions, and if we have or not an stare decisis norm that can make it more predictable, that in the next case we should use this exception that was created. I'm sorry if I am talking too much, and I want to hear you more. I will shut up now.
No, thank you very much. It was a pleasure listening to you. I don't know if anyone else wants to perhaps ask or Boyan to reply.
I'm not replying. I'm just thank you for the answer. It was perfectly clear on just for the first part of the question. I think we misunderstood each other a bit, but the answer was perfectly clear. The idea is that if we are modifying the antecedent to make it more clear, then there has to be a meaning prior to the identified meaning of the interpreter, and then the kind of this skepticism, or at least total skepticism or radical skepticism, however you want to call it. For me, it's more or less the same. I mean, it's just this thing. But the second part is I was wondering, and that is my follow-up question, whether it would be. I mean, I don't know about the emotional part, but I'm completely fine with the evaluative part, in the sense that it could be prompted psychologically by a sense of injustice. For example, if we apply the general norm interpreted in a certain way to a case, for example, of the father, and it would seem a mistake if we find the barber on the for spilling the blood on the street of his I don't know even how you call, of his client. Okay. And but still, I was whether this holds. So if we can't make this distinction that you're mentioning, the structural distinction, and I want to make this clear, you probably have an answer for this. How can we even say that an exception was somehow created, on which basis? Structurally, so this is the idea. From a Guastinian standpoint, it would go something like this: the creation of a norm that was not explicit before, so it's an act of construction or judicial construction, and all acts of construction are the result of creative interpretation in the cognitive sense, in the sense that we are making a norm that wasn't explicitly present in the formulation of the source of law. How do we know that we made the norm? Because we ran out of interpretative methods or canons of interpretation and interpretative doctrine. So if we run out of interpretative doctrine and canons of interpretation, and we didn't reach the norm, that means that eventually we made the norm. Maybe it can be spotted in the judicial argumentation in this sense. The judges made a move that isn't a linguistic interpretation, systemic interpretation, historical interpretation, or teleological interpretation. So they made a move in the argumentation that's kind of not allowed, or they moved the figure on the chessboard in a way that they are not supposed to move it, and it just becomes either it becomes a rule according to stare decisis, or whatever it happens with it in the legal system afterwards. That doesn't have to be relevant. But doesn't that imply kind of systemic distinction in this sense of systemic that you were explicating? That would be it.
Okay. So, for this point, first, I must make a point clear. I'm trying to defend one way of understanding exceptions, but of course, is not the only one in the literature. Just briefly, there are some that make in order to identify an exception, they say, there are negative properties in the antecedent. I've written in the paper the reasons why this does not sustain. There are other authors, like, for example, Luis Duarte de Almeida, that say we identify exceptions by analyzing the burden of proof. Is an exception everything that must be proved by the defendant? Well, I think it has many problems. Just to say one, this means that the burden of proof is a norm without exception, and exceptions is only limited to institutionalized process of decisions, which is, I think, problematic, but I will not go up for this. And from this point of view, from the point of view that I'm trying to defend, is a systematic approach to exceptions. So I think from this systematic approach, we can distinguish between a static and a dynamic approach. From an static approach, I think what you were just discussing, I think it can be explained in this sense. For example, the judge that created the exception for the minor, for the father of the minor with ASD. Okay, I can locate this event temporarily and spatially. I can locate it and I can identify the decision. I can say, of course, I can describe this, that he has created a distinction, that he has created a new norm, and we can call that an exception in order to differentiate or to highlight that this act was made. So he created the distinction, and this distinction, in order to differentiate from the other, is an exception. We can use this minimal sense of exception from an static point of view. From a dynamic point of view, I think this is the most problematic. Let us think about not the moment this distinction was created, but, for example, now that 2 years has passed, there are lots of decisions that have been made, and I have this norm, and I have this norm that says that people, fathers with children with ASD, are allowed to go out during the quarantine for a certain time of period. They can go out. And I trying to think which part of the antecedent is the exception and why is it? Or to use the classic example of Hart, no vehicles in the park unless it's an ambulance. And I say the ambulance is the exception. And I say why I'm doing this. And I think that we can reconstruct all the operations that some judge has been made in the past in order to get this result. For example, I can reconstruct the norm, and I think, well, there is one part of it that obeys certain purpose. For example, quarantine. It is a means to promote health, and not follow allows going out for fathers with minors with ASD. Okay, this is a means to the purpose of mental health. And I am thinking, well, maybe the judge made a balancing between them, and this is the result, so this is the special treatment. Or I can not use this language, and I can reconstruct the operations as Andrea Dolcetti and Giovanni Battista did, using, instead of the language of principles, using the language of rules. And I think, well, this is a conflict between a mandatory norm and a prohibited norm, and this was the way of solving it. What I'm trying to say is that I can reconstruct the different elements of the antecedent of a norm either as a requirement, because of a means of an end, as an identification of a certain rule, or as an exception. I can say that here there was a balance, here was a conflict between rules, and I can reconstruct this like that. The point I'm trying to say is that if we are trying to point out something really precise, the notion of exception, or I'm sorry, the expression exceptions really points out or really clarifies the static moment, the moment that distinction was made. But after that distinction was made, once we are in a dynamic approach, once we are dealing with norms that has been created in the past, and I'm trying to reconstruct or identify deception in them, I think the label loses its meaning. I cannot distinguish between requirements and exceptions as an structural part. Rather, I will use it for ideological purposes. For example, if I want to say that my fathers with minors with ASD are allowed to go out in the quarantine, and I believe this is an exception, maybe I'm doing this in order to argue that only this case are restricted to, I'm sorry, are allowed to go out in the quarantine and not any other similar case. You know? I'm prohibiting extensive interpretations of this part of the norm by labeling it exception. So people with other, I don't know, health needs wouldn't or were not going to be allowed to go out in the quarantine. I don't know if this answer was better or worse than the other ones, but I tried my best.
Perfect. Thank you.
Thank you very much.
So if we don't have any more questions, I believe we can conclude. Thank you once again, Victor, for being our guest. Hopefully we'll see each other once more and once again, perhaps in Belgrade, if the opportunities let us do so. So that's it. I hope it was useful to you as well.
It's been a wonderful experience. I really thank you very much for your questions, your time. I'm really, really happy to see old friends, to get to know new ones, and I'm really hope that we'll see each other person in Belgrade very soon.
Thank you.
Thank you very much.
Yzaguirre.
Likewise.
Thank you, Victor.
Bye.
Bye.
Pleasure.